This is Barry Zalma on Insurance. I am an attorney who has retired from the active practice of law and now spend my time as an insurance claims consultant, an insurance claims expert witness, an author and producer of these videos. Today I'd like to talk about the construction contract and how it is important to every insurance policy, every insurance claims person dealing with a construction defect claim or lawsuit. When a construction contract, like every other contract, is unambiguous, the party's intent may be determined from the contract alone, and it is the duty of the court, not the jury, to state its meaning, because it is a question of law, not fact. Construction contracts are governed by the same rules as all other contracts. When a court is called upon to interpret a construction contract, its terms are given their ordinary meaning and generally accepted meaning with the court, working to give effect to the intent of the parties to the contract unless the contract itself gives special meaning to the contract. For example, in Missouri, the cardinal principle of contract interpretation is to ascertain the intention of the parties and give effect to that intent. The terms of a contract are read as a whole to determine the intention of the parties and are given their plain, ordinary, and usual meaning. Additionally, each term of a contract is construed to avoid rendering other terms meaningless. A construction that attributes a reasonable meaning to all the provisions of the agreement is preferable to one that leaves some of the provisions without function or sense. An Indiana court, for instance, held that the intent relevant in contract matters is not the parties' subjective intents, but the outward manifestation of it. The cardinal rule of contract interpretation is to ascertain the intention of the parties from their expression of it. If the aims are kept in mind during drafting, a construction contract should be reasonably straightforward to understand. A contract benefits both the contractor and the owner. Both parties need a contract as protection from each other. A construction contract should always be written. It should, like all other contracts, set forth in detail the duties and obligations of the parties to the contract. It should communicate the scope of work to be rendered and the extent to which each party is involved in the differing aspects of the project. Contracts serve as a means of documenting the services and assets to be exchanged during the course of a project. The contract is important, not only to finalize the deal in the minds of the parties to the construction project, but also to help define the performance of the work and may even determine who bears the tax burden. A basic construction contract is negotiated by the parties and will be interpreted by a court following the normal rules of contract interpretation. Another type of contract is called a contract of adhesion. When the parties to the contract are of unequal bargaining power, such as a multinational corporation dealing with a local builder, the more powerful party can force the less powerful party into a contract not subject to negotiation. The less powerful contractor is only able to specify the amount of compensation. The negotiated contract, where both parties deal equally with each other, is preferable and fair to both parties. When dealing with large or powerful entities, there is no way to avoid the contract of adhesion. However, Even a contract of adhesion is subject to negotiation over price and some terms and conditions. Negotiation should never be avoided. Adhesion contracts should never be accepted on the first offer. Very few contracts are take-it-or-leave-it propositions. Adhesion contracts can be left intact but modified by endorsements signed by all parties. All contracts should be negotiated at arm's length, recognizing that no two contracts will be exactly alike, because no two properties are exactly alike. As the U.S. Supreme Court explained, such value may be good evidence of the maximum available if one can assume that parties of equal knowledge and negotiating skill agreed upon the figure through arm's-length bargaining, unhindered by any considerations tugging against the interest of the parties ostensibly represented in the negotiation. This is a case called Ortiz versus Fiberboard Corporation, a U.S. Supreme Court 1999 decision. Although an arm's-length contract negotiation usually requires both parties to be equal, some may be more equal than others. The contracting parties should, within reason, use the power available to their benefit. If one party is weaker than the other, and the terms proposed will make it difficult to profit from the transaction, the weaker party has the option to refuse to enter into the contract. When a contract of adhesion is accepted, the courts protect the weaker party, and because of the unequal bargaining power of the parties, treat the contract of adhesion differently than negotiated contracts. Courts will interpret any ambiguities in the contract of adhesion against the drafter of the contract to equalize the rights of the parties and prevent the stronger contracting party from taking advantage of the weaker party. Contracts of adhesion should be avoided if at all possible, although the profits that can be made from a contract of adhesion often outweigh the one-sided nature of the contract. The builder or contractor who signs a contract of adhesion should read the contract carefully, and preferably have it reviewed by his or her counsel to ascertain that all of the conditions can be and will be accomplished before the contract is signed in a manner that will result in a profit. To protect themselves, parties to construction contracts often use standardized form contracts that all parties understand. The following discussion outlines these contract forms, their advantages and disadvantages. Purchasing a standard and industry-accepted form contract is less expensive than asking an attorney to draft a specific contract from scratch. Although on a large project, it is often a good idea to involve counsel to review and/or modify the standardized forms to protect the client's interests. Generally, though, sources that create construction contracts are equipped to protect standardized form users because they are familiar with new case law that affects the interpretation of the contracts, new statutes that affect the interpretation or application of the contract terms, the need to resolve legal issues that become apparent so that they will not arise in future contracts, the need to conform to changing building codes and construction-related statutes, and the need to conform to changing insurance policy wording and regulations. The most extensively used standardized forms are those that have been developed by the American Institute of Architects. Modern AIA standardized contracts and administrative forms are recognized throughout the design and construction industry as the benchmark documents for managing transactions and relationships involved in construction projects. In addition, a significant body of case law concerning contracts for design and construction exists, interpreting the language of the AIA standard forms. The more case law there is interpreting standard contract forms, the more certainty the parties to the contract have concerning their rights and obligations under the contract. Contract terms that have been tested in the crucible of litigation are less likely to be the subject of future litigation. AIA has established many practices that are common in the construction industry today, including arbitration, the one-year correction period, and the architect's role in deciding disputes. AIA documents are used almost universally in the construction industry on major construction projects. On smaller projects, contracts are shorter and less demanding. The AIA regularly revises its documents to take into account recent developments in the construction industry. New documents are standardized for different types of construction management and for international practice for use by designers, builders, developers, architects, contractors, and others in the trade. The AIA reported that its drafting process is a thorough and deliberate approach that strives to achieve a fair balance among interests affected by the contract documents. The process is based on the cooperative input of a documents committee of practicing architects who have been appointed based on their experience, regional diversity, and variety of practices. Beyond the input of these committee members, the AIA also solicits feedback from owners, general contractors, engineers, subcontractors, sureties, lawyers, insurers, and others. By considering the opinions of a broad range of disciplines, the AIA strives to publish documents that account for the best interests of all parties affected by them. AIA calls its different categories of documents either families or series. This double method of organizing the documents is designed to make it quicker and easier for users to select the documents appropriate for their projects. Documents in the same family are coordinated to tie together the various legal and working relationships of the same project types or delivery methods. They are linked by common terminology and procedures so that various forms can be adopted by reference into the wording of the basic contract. These contracts from the AIA are similarly created as are insurance contracts created by the Insurance Services Office, or ISO. They can be read easily, although the language sometimes seems difficult to understand, and can be clear because of multiple years of litigation and court opinions. This video was adapted from my book, Construction Defects and Insurance, Volume 1, which is available as part of an 8-volume series on construction defects and insurance from Amazon.com as both a Kindle book and as a paperback. If you found this video to be useful, please refer it to your colleagues and subscribe to the YouTube channel as well as to my blog so that you can learn about future blog postings and videos. Thank you again for your attention.